As Lagos challenges the acquittal and discharge of Al-Mustapha and Shofolaon, Law Weekly looks at the reactions trailing the move. Legal practitioner Adegboruwa will join me shortly on the program to give his perspective on the appeal and the justice system. That's the lineup for today, but first let's do a quick recap of the top legal stories in the news. I am Shola Shoyeli. We begin with the report that the Lagos State government has filed 14 grounds of appeal at the Supreme Court against the judgment of the Court of Appeal which acquitted and discharged Major Hamza Al-Mustapha and Lateef Shofolaon on charges of murder of Alhaja Kudirat Abiola. The state's Attorney General and Commissioner for Justice, Mr. Adegboruwa, at a press briefing on law and order last week Tuesday, said that his ministry had filed 2 separate notices of appeal against the judgments of the Court of Appeal. While the state government filed 6 grounds of appeal against Al-Mustapha, it filed 8 against Shofolaon. Justice Mojisola Dada of the Lagos High Court had on the 30th of January 2012 sentenced both men to death by hanging for the murder of Kudirat Abiola. But the Court of Appeal Lagos on the 12th of July 2013 set aside the judgment and quashed the death sentence passed. In the grounds of appeal, the Attorney General argued that the Court of Appeal erred in law by acquitting and discharging the 2 men when the evidence linking them to the crime was not materially challenged. Mr. Ekpaye also argued that the contradictions in the testimonies of the prosecution witnesses were immaterial and urged the Supreme Court to affirm the death penalty. From Lagos State in southwest Nigeria, we move to Rivers State in the south-south. A high court sitting in Port Harcourt, the state capital, last week Friday gave an order restraining the Commission of Inquiry into the Rivers State House of Assembly crisis from investigating the case. The presiding judge of the State High Court, Justice Iyayi Lamikara, who issued the order on Friday, also restrained the state governor, Mr. Rotimi Amechi, and the Attorney General and Commissioner for Justice, Mr. Woguboms, from receiving or implementing any recommendation from the commission. A lawmaker representing Port Harcourt Constituency 3 in the Assembly, Mr. Victor Inhu, had approached the court asking it to declare the Commission of Inquiry set up by the state governor as illegal and unconstitutional. In Abuja, Nigeria's Federal Capital Territory, a magistrate court has set free the chairman of the People's Democratic Party, PDP, in Omuma local government area of Rivers State, Mr. Charles Amefule, charged with sedition by the police. Mr. Amefule was arrested in Rivers State and arraigned in Abuja over an interview he granted to a Port Harcourt-based radio station on the crisis in the state chapter of the PDP. The police said Amefule's interview amounted to criminal conspiracy, false statements, and incitement. Following the disclosure by the prosecutor that the police is yet to conclude its investigation of the accused person, Magistrate Enahoro set him free. And we round off with news from South Africa, where prosecutors say Paralympic gold medalist Oscar Pistorius will be indicted for premeditated murder on Monday, and he will go on trial early in 2014 for shooting dead his girlfriend. In a sober twist, Pistorius, popularly known as the Blade Runner, will be accused on August 19th, the day the woman he killed, River Steenkamp, would have celebrated her 30th birthday. Prosecutors said an exact date for the trial will likely be decided on Monday when Pistorius next appears in court, but refused to comment on reports that he will face another charges for allegedly discharging a firearm recklessly in 2 separate incidents. However, it was confirmed that the main charge would definitely be premeditated murder, meaning Pistorius could be sentenced to 25 years in prison if convicted. Pistorius was initially charged with premeditated murder for Steenkamp's death for bail purposes while police investigated the circumstances of the Valentine's Day shooting. Police said last week that they had completed their 6-month investigation and are convinced Pistorius had a charge to answer to. Pistorius denies the charge and says he shot Steenkamp by mistake in the early hours of February 14 because he thought she was an intruder at his Pretoria gated community villa.
You see, life has just got easier. You stay connected to Channels TV where news and innovations are shaping our world. Simply log on to channelstv.com to get the breaking news. Browse the homepage according to what matters to you. Tap on the extended coverage of business, sports, politics, lifestyle, infotech, entertainment, health, world news, and lots more. Click on the live link and see the news in real time. Do you want to watch the latest video of the day? It's just a click away. Friend us on Facebook, YouTube, follow us on Twitter, Google+, participate in Channels TV poll and share your comments. It's a website you can talk to. Your voice will be heard.
channelstv.com. The news at your fingertips.
Welcome back. Last week Tuesday, the Attorney General and Commissioner for Justice in Lagos, Mr. Adegboruwa, declared during a press briefing on law and order that after studying the Court of Appeal judgments, the Lagos State government has filed its appeal.
There were two judgments, one in respect of Al-mustapha and the other in respect of judicial. Both had been studied closely, and we came to the conclusion in this ministry that there were good grounds for appeal, and we have since filed all the necessary papers. Officially, we have put in our indication that we want to contest the judgment of the Court of Appeal at the Supreme Court. So that appeal has been filed.
Now, in the early reactions trailing that announcement, the lawyer on the other side, Mr. Olalekan Ojo, says, while we recognize the fact that the Lagos State government has the right to appeal, the appeal cannot affect the freedom of the persons who have been discharged and acquitted by the Court of Appeal. The appeal cannot restore the judgment of the High Court, and there is nothing like stay of execution here. The judgment of the Court of Appeal cannot be stayed. My guest, Mr. Adegboruwa, needs no elaborate introduction. He has led a series of protests against the tolling of the Lekki-Epe Expressway and is now in court challenging the tolling of the new Ikoyi-Lekki Link Bridge. This legal practitioner is often at the forefront of challenging what he calls excessive lawlessness and disregard for the rule of law. He joins me on the program now. You're one of those that urged the Lagos State government to challenge the Court of Appeal judgment freeing Al-mustapha and Alhaji Lateef Shofalaun. Now that the state has filed the appeal, what are your thoughts about this?
I must commend the Lagos State government, all lawyers in the Ministry of Justice, the Attorney General, and indeed all past officers, especially Professor Yemi Osinbajo, Senior Advocate of Nigeria, for the courage and the diligence that they have exhibited in relation not only to Al-mustapha's matter, but in the prosecution of all those anti-democratic forces and agents who try to put us under a very terroristic regime in this country. And to that extent, I thought that it was better that we see that effort to a logical conclusion, not to allow it to be terminated at the Court of Appeal. And secondly, also because I didn't want that precedent to become a part of our judicial system, whereby politics has strayed very disappointingly into the corridors of judicial decisions. So I felt that it was necessary for the Lagos State government to see that matter to a logical end in the interest of the legal process in Nigeria, and also in the interest of democracy, and also for the sake of the limb and life of Kudirat Abiola, Chief Moshood Abiola, and those of us who suffered dehumanization, detention, those who have lost their lives. So it will have become a terrible blow for all of us if that process had been terminated at the level of the Court of Appeal. Don't forget that the bandwagon of the disappointment in terms of these trials has really affected the psyche of Nigerians. General Isha Bamayi was freed. Mr. Mohammed Abacha was freed. Mohammed Lawal Idris was freed. So the question we're all asking is it that Kudirat didn't die? Is it that I was not detained? Is it that Chief Ibrahim Adesanya was not attempted to be assassinated inside his Mercedes-Benz? Is it that Afe Rewane didn't die? You know, because even the supposed killers of Afe Rewane were eventually set free. So we felt that it was too much for us to bear. The impression being created that people are above the law. People can kill and get away with it. People can manipulate the judicial system. So it was important for us to get to the highest echelon of the judicial hierarchy in Nigeria. Was why we urged the Lagos State government to ensure that they filed an appeal against that judgment.
And this is irrespective of whichever way that the decision of the Supreme Court will go?
Well, we feel that indeed, because of the time lag, it was necessary that in the course of pursuing that appeal, facts will emerge. 2015 will have come and expose all the underhand deals, because you remember that not long after Mustapha was released, a very close person to the president, Mr. Gulak, visited the chairman of the People Democratic Party to thank Alhaji Bamaga Tukur for all the efforts that the executive and politicians took in seeing to the release of Al-Mustapha. He said categorically that his release could not have come through a judicial process alone, which means that there were underhand political interventions, there were executive interference in the judicial system, which has been confirmed by Mustapha himself. So I believe that it's important that if another panel reviewing the facts that have come to light since his release will try and remove politics and sentiments from the cold facts of the case that was charged to court. So I think it is necessary that at the time we will get to the Supreme Court, greater wisdom will have prevailed for a reversal of that decision.
Now, one issue that the trial threw up, which you've also alluded to, is the length of time that it took to conclude it. And it brings to mind again the call for judicial reforms. What kind of judicial reforms do you think is needed to enhance or improve the system?
Well, in this particular trial, unfortunately, the accused person set out from day one to weary the prosecution, to weary the witnesses, and then get away with the offense. Because you know the strategy was, this case was commenced by Justice Oyewole. So there were applications upon applications, trials within trials, confessional statements were denied. And indeed, at a particular time, the judge was accused of bias to the extent that he was asked to disqualify himself. So the accused person took a long route of about 8 years, just merry-go-rounding and perambulating around the justice circle without anything being achieved. By the time the case eventually got to Justice Dada, some of the co-accused, such as Mohammed Abacha, General Isha Abameye, Mohammed Laborawa, had been freed. The witnesses had been standing the dock for close to 10 years, and they are human beings who walk the streets of Nigerians. They have been intimidated. They have been appealed to by the families of the accused persons, so that they came back to be renouncing the very statement that got them to become witnesses. So such trial should not have been allowed to last that long, for 14 years. So surely, even the witnesses, the prosecution, the judges will have become wearied by the length of the trial. So the reform we advocate is that once a criminal trial has commenced, it should be heard from day to day. That's number one. Number two is the facilities. We should ensure that, because when you see a judge writing a judgment as long as 362 pages, you imagine what the record of proceedings will have been like. And it's not that the judge is handling only this case. Justice Dada, you know, will be handling land matters, you'll be handling other chieftaincy cases. So in the course of it, the judge will be wearied, so that the logical application of law to the facts will have become strained, so that human error could come in. So the cases should be heard from day to day. The infrastructure, interpreters, stenography, the people who should be able to take down the proceedings, and then legal assistance given to the judges who will research into the legal points and bring them to the judge to take a decision. And then we should have a recourse to whether we will apply the issue of jury, so that it will just not leave a single person to the sole discretion of determining the guilt of this person, especially in serious cases like this. We could call people from various fields of interest, journalists, market women, engineers. Yes, and then have them sit down together to, based on the facts, give an advice that the judge will need to consider at the end of the day.
So you really think a jury system can work in Nigeria?
Oh, surely it can work in Nigeria, especially now that you have high-profile cases. You know, the judges have become targets, if you can see, of various applications and petitions to the National Judicial Council, so that judges at times are intimidated. The lawyers themselves have clout in terms of the senior counsel, if you look at the EFCC cases, the high-profile cases have not gotten anywhere because of the weight of the lawyers who are involved. They easily intimidate the judges. They file applications. They take the matters to NBA. They take the matters to NJC. And at the end of the day, judges are dismissed. So every judge is afraid to even handle some cases. So at times, we need to shield the judges from the weight and caliber and profile of these high-profile accused persons and their counsel. So indeed, when you get a jury, you isolate the judge from that direct personal attack, because you can see that the mistake we are making is to designate certain judges as criminal court, to designate certain judges as handling EFCC cases. Those people are now becoming targets and victims of undue attack, and they have families. They're human beings. So at the end of the day, people go back and say, why don't you watch it, please? Are you the only judge in the judiciary? So I think that bringing a jury will also help to at least make it look like it's not only one person that is taking the decision, and that will affect us a lot.
But they could also be intimidated. They could also be manipulated. I mean, the jury will comprise members of the society, this society too.
Well, if you see a person who can manipulate and intimidate a jury, then that person should not be allowed to focus his power and arsenal on a single judge. So that's the more reason why we should do it. And then secondly is that, look, the criminal procedural law that we have in Lagos State, and indeed all over Nigeria, is outdated. And I thank God for Lagos State for reviewing that procedure now and then. But you just need to keep reviewing it, because crimes like terrorism, Boko Haram, are never in the criminal code. They were never anticipated. All these cybercrime offenses are not taken care of in the criminal code. So we need to update the criminal code system to take care of lesbianism, of gay. These things are not part of our laws, and they are now part of society. So we must sit down day by day to keep reviewing the laws to take care of emerging trends of criminal activities in the land.
Another angle to the Al-Mustapha trial is the role played by lawyers. Some people have argued that lawyers were responsible for most of the delay that we saw in court, during the length of that trial. What's your take on that?
Well, you see, the problem we have is the Constitution, and I can't see it as a problem. Unlike Britain or United States, we have a section 36 in this country that guarantees the right to fair hearing. And part of that right is that an accused person is deemed innocent until the contrary is proved. And secondly is that once you have charged him, he's entitled to be deemed to be innocent. Because of that, it's always advisable to follow this adversarial system of justice, whereby the prosecution who is making the allegation is having the burden to prove. And once that burden is discredited by a single doubt, we have a problem. So you don't blame the lawyers. It is unlike the United States or other foreign jurisdictions. Our Constitution guarantees the right to fair hearing, and that cannot be abridged. That cannot be compromised. That cannot be abrogated. And because the reason why we do this is because in the African perspective, complainants use issues of struggling over girlfriend and boyfriend to punish their adversaries. Landlords take the police to punish their tenants. And if you are not careful, you see cases of innocent people ending up in custody. That's why the law says that it is better for us to allow 99 people to go free than for one single person to go punished without justification. So these cases of delay by lawyers is taken care of by the Constitution, because there is this allowance for the prosecution to be able to prove beyond convincing or any reasonable doubt that indeed an offense has been committed. So we have that challenge of comparing the constitutional right of accused person with that of right to speedy trial. And we thought that we should balance the equation. And that's why we said, let the hearing take place from day to day. Let there be a schedule that will be clear to the accused person, that will be clear to the prosecution. That way, you can balance the equation between the right of speedy trial and the right of the accused person to fair hearing.
So no matter the number of applications that the accused person brings, once it goes on a day-to-day basis,
they should be heard all together. And indeed, from the criminal procedural law of Lagos State now, interlocutory appeals are discouraged. What the Lagos State Administration of Criminal Justice Laws now says is that, look, once a judge has started a hearing, he should be hearing it from day to day. And interlocutory appeals can be taken at the end of the judgment. And any preliminary objection, any defect in the charge can be taken along with the final judgment of the judge. Because when that judgment is given and you have the opportunity to appeal, other interlocutory matters could be subsumed inside the main and substantive appeal. That way, the accused person is able to know his fate quickly. The prosecution is able to know the strength of the case it has against the accused person, and everybody will go to...
that is a law that works.
I believe that the better way to ensure speedy hearing is to hear from day to day. You cannot curtail the right of persons to apply or file applications because of the constitutional right to fair hearing. But when you are hearing day to day, every application, however frivolous they are, they will be heard and determined, and the main case will still be on target. And not just for the criminal cases. You know, the way you say we should prosecute election petition in 180 days, you see that it has worked injustice, in the sense that the Supreme Court has become like a burial ground for these election petitions. Because when you get there, they just tell you that we have no time. We are sorry, you're out of time. And so the gravamen of those petitions are being destroyed for the issue of time. So what I say is that even if you are hearing them day to day, hear all the issues involved, so that when eventually you get to the Supreme Court, all the matters can be taken substantively. So it's not just in criminal trial, but in election petitions, in civil cases, in matters relating to agreements and commercial transactions, so that society can move and we can drag the wheel of progress more faster than we are doing currently. Otherwise, the way the prisons are now, the best way to decongest them is to ensure that criminal trials go on day to day, and then we can decongest the prisons and determine the fate of suspects.
Finally, there's this issue that a lot of people are curious about. I'm also curious about it, and I said I'd ask you. You've gone to court a number of times to challenge a number of policies of the Lagos state government, especially on the issue of tolling. And what would be your response to those who say that you're a busybody, that it appears that you have issues with the Lagos state government?
Not at all. As a matter of fact, our interest is to use law to defend the interests of people who don't have the capacity or the opportunity. And we have done that not only in Lagos. It's just that my practice is based in Lagos. I have filed cases against the Ondo State government in respect of the implementation of the Osopadec appropriation law by giving 30% derivation to the oil-producing areas of Ondo State. I have filed cases against President Goodluck Jonathan in respect of the oil subsidy protest that we did in January 2012, and the case is still pending before Justice Candido Johnson of the Lagos High Court. I, along with other NBA executives, we took up that case, and I was in that protest and led that protest together with the Joint Action Congress of Nigeria. So I have no grounds against Lagos State. As a matter of fact, Governor Babatunde...
something that you have also heard?
Well, I have heard it. I have it, and indeed not just that, I have been told to pack my things and leave Lagos State if I'm not happy with the system of management of the governance of Lagos State. You see, the truth is that having spent over 20 years in this state, I have contributed in one way or the other towards the development of the state, either in terms of employment, either in terms of payment of tax, either in terms of contribution towards democracy. Lagos State is the capital of democratic activity in Nigeria. All the human rights organizations, they took root from here. Mrs. Ransom Kuti, Fela Ransom Kuti, Chief Gani Fawemi, they are from Ogun State, they are from Ondo State. Nobody ever told them not to take up any struggle. So I think it's pandering to sentiment, to trying to intimidate people to come to say, because you are from Ondo State, you are targeting Lagos State. I admire Governor Babatunde Fashola. I must tell you, secretly I admire him. I'll tell you, because he, to me, stands in the line of integrity. I have read a lot about him in terms of his private life. I have absolute respect for his sterling qualities in terms of the integrity he has brought to administration in Nigeria. Through him and his personalities, people of substance. You see a senior advocate, Mr. Mohammed Begore, going to contest for election in Kwara State, and so many other people. When they look at people like him and say, if a senior advocate can rule Lagos State in this way, they will also be encouraged to go into governance. So governance is no longer for dropouts. So to that extent, he has brought quality into the governance of Nigeria, and I admire him for that. But nonetheless, we must say that Lagos State is meant for big people, rich people, less privileged, mechanics, workmen, Makoko people. So he's a governor of the rich and a governor of the poor. You cannot attempt to make a state that of the elite alone. You must allow people who don't have the opportunity, who are in the slums, in Makoko, in Ajegunle, in Ijora, to exist. He's a governor of lawyers, a governor of illiterates, a governor of bankers, a governor of journalists, and a governor of market women. Everybody. So he should carry all of us along as he's trying to develop Lagos. And we support him. That's why we encourage people to pay their tax. So I have no grounds against Lagos State government. Indeed, I admire this particular government as being a beacon to other states that are copying him for progress. So, and I encourage him to do more. But he should be a governor for the less privileged and for the elite too.
That's where we wrap up this week's edition of the program. You can catch any part of the program you missed by logging into youtube.com/channelsweb. Please send in any comments via email, Facebook, or Twitter. I am Shola Shayeli. Thank you for watching.